Most of us assume that when a family breaks down, the court steps in as a neutral referee. We expect a system built to discover the truth, weigh the facts, and deliver a fair resolution. In business, companies like Amazon and Apple protect themselves with moats built on scale and software ecosystems. Family law uses a different architecture. It secures its professional dominance through state authority, procedural complexity, and the inherent emotional vulnerability of its participants. Looking closer at this diagram, you can see how absolute the system's reach really is. Unlike almost any other industry, family law touches nearly every aspect of human existence. It dictates where you live, how you manage your finances, your access to healthcare, and whether or not you get to tuck your children into bed. To maintain control over all those facets of life, the profession has organized its defenses into 3 concentric rings. The outer ring restricts basic access. The middle ring dictates who can successfully participate, and the inner core decides who actually holds influence. By examining these 3 defensive layers, it becomes clear why parents walking into a courthouse rarely feel like they are purchasing a helpful service. They quickly realize they are trapped inside a procedural gauntlet. The outer ring, the barrier to access, stops many people before they ever reach a hearing. Getting your foot in the door requires knowing exactly where to file, which precise forms are required, the strict deadlines that apply, and what jurisdiction controls your case. This creates massive information asymmetry. A mother navigating a custody dispute is experiencing a once-in-a-lifetime crisis. The professional sitting across the table from her has managed hundreds of these hearings this year alone. One side is trying to survive a life event, and the other is simply executing a profession. The written statutes are only part of the problem. The system is heavily governed by hidden rules, local courtroom cultures, unwritten expectations, and specific judicial preferences. These aren't taught in public education campaigns. They are learned entirely through repetitive professional exposure. The result is that parents routinely make crucial mistakes early on. Before they ever get the chance to argue the facts of their case, they are outmaneuvered by an opposing lawyer who is just treating this like another Tuesday. If a parent does manage to breach that outer barrier, they hit the middle ring, participation. And here they learn a hard lesson. In family court, the absolute truth matters significantly less than procedural correctness. Let's look at how the court controls language through this translation pipeline. A parent's raw human experience, like missing a son's baseball game because of a late shift, enters the funnel as disorganized, emotional truth. To be heard by the judge, those nodes must be translated by a professional into rigid, legally recognizable blocks, like failure to exercise parenting time. That translation is mandatory because of evidence control. As you can see, those legal blocks have to travel down a procedural conveyor belt. Having proof of your claims means nothing if it doesn't pass strict mechanical gates of admissibility, proper formatting, and exact timing. A strong argument presented incorrectly is instantly knocked off the track, while a weaker argument formatted perfectly glides right through. Navigating this demands intense focus, but the system actively works against human biology. The trauma of divorce, abuse allegations, or housing instability severely reduces a person's cognitive bandwidth. Memory, planning, and attention degrade exactly when the court demands flawless executive function. You pair rigid procedural gates with intense emotional collapse, and self-representation becomes nearly impossible. The parent is forced into total dependency on expensive, licensed professionals just to have their voice heard. That dependency leads us to the inner core, influence. This is the deepest moat, and it dictates what it actually takes to meaningfully change an outcome. Inside this core, relationship capital is everything. Attorneys, judges, evaluators, and mediators work with each other year after year. Over time, that familiarity breeds trust, and trust functions as a localized currency. Outsiders simply cannot penetrate that network. Those professional networks operate within an economic model that structurally rewards complexity. Take a look at this escalation cycle. When a case becomes complicated, it triggers a chain reaction. More motions lead to more discovery, which requires more experts, generating higher costs. The ecosystem generates more revenue precisely because the loop keeps expanding. As this cycle spins, time becomes weaponized. The prolonged delay inherently favors the professionals, who are getting paid by the hour, while simultaneously crushing the family's savings, mental health, and endurance. Winning at this deepest level rarely hinges on the merits of a parent's love or their dedication to their child. It depends on their financial capital, their psychological endurance, and their access to that insider ecosystem. Positioned at the dead center of all these defensive rings are the children. They are the ones who absorb the systemic consequences of the moat. They endure the prolonged conflict, the fragmented decisions, and the delayed stability, while the adults argue over procedure. For decades, this power dynamic was immovable, but the introduction of artificial intelligence is beginning to alter the landscape. AI attacks the foundations of these moats by directly addressing the scarcity of knowledge and documentation. By organizing evidence, analyzing legal language at scale, and identifying procedural inconsistencies, technology provides families with the transparency needed to challenge the informal networks and unwritten rules of the inner core. This technological shift transitions the power dynamic toward a knowledge partnership. Lawyers find their role redefined, moving from exclusive gatekeepers of a complex system to strategic guides who augment a family's own understanding. If we want a justice system that actually serves children, it must derive its effectiveness from clarity rather than complexity. A family in crisis should never be forced to cross 10 layers of an institutional moat just to protect their own kids.
Conservative, proven, ready to lead.